Hello, and welcome back to the Blackstone Solicitors YouTube channel, where we make sense of legal matters, one topic at a time. Today we're talking about a subject that touches so many families across the UK. Dementia and lasting power of attorney, or LPA for short. If you've ever wondered, when should I set up an LPA? Can someone with dementia still make one? Or, why is this so important? Stay tuned. We're breaking it all down for you. Dementia is sadly becoming more common, affecting nearly 1 million people in the UK. It doesn't just affect memory, it can change how someone makes decisions, understands information, or communicates with others. And here's the key issue. When someone loses mental capacity, they also lose the legal right to make certain decisions, including appointing someone to help them. That's where a lasting power of attorney comes in. So, what exactly is a lasting power of attorney, or LPA? Well, an LPA is a legal document that lets you appoint someone you trust, known as your attorney, to make decisions on your behalf if you lose the capacity to do so. There are actually two types. The first one is the Health and Welfare LPA. This covers decisions like medical treatment, care, or even where you live. The second is the Property and Financial Affairs LPA, which covers your money, bills, and property. You can choose to make one or both depending on your needs. Most people dealing with dementia tend to go for both. Now, here's the golden rule. Make an LPA as early as possible. To make a valid LPA, you need to have mental capacity. That means you understand what the LPA is, what powers it gives, and the consequences of signing it. Unfortunately, once capacity is lost, it's just too late to create an LPA. The family would then need to apply to the Court of Protection for a deputyship, which is more costly, time-consuming, and restrictive. Can a person with dementia still make an LPA? Yes, but only if they still have capacity at the time of signing. Many people in the early stages of dementia still have the mental capacity to make an LPA. It may involve a capacity assessment, particularly if a solicitor, doctor, or family member is unsure. At Blackstone Solicitors, we regularly help families navigate this carefully and legally. Why does it matter for families? Well, just imagine this. Your loved one starts struggling to manage their bank account, or maybe they need full-time care. If there's no LPA in place, you'll have no legal right to access their accounts, speak to care providers, or make decisions on their behalf, even if you're their spouse or child. With a registered LPA, you can pay bills or manage finances, make care and medical decisions, reduce stress and conflict within the family, and avoid those lengthy court applications. In short, it gives peace of mind, dignity, and protection. How can Blackstone Solicitors help? We understand how emotional and complex these situations can be. That's why we offer professional, sensitive advice for individuals and families facing dementia. We'll 1. Assess capacity where necessary. 2. Ensure forms are filled correctly and legally. 3. Guide you through witnessing and registration. 4. Help avoid common mistakes that lead to rejection. And most importantly, we'll make sure it's done right the first time. If you or a loved one are concerned about dementia, don't wait. Start the conversation today. And if you found this video helpful, don't forget to like, subscribe, and share it with someone who may need this information.